After 2.5 months of testimony and dozens of witnesses, we are finally expecting to receive a verdict in Donald Trump's New York civil fraud trial. The judge has already ruled that the former president inflated his net worth on financial documents in order to receive business benefits. Trump could be hit with several $100 million in fines. He could also receive a ban from conducting any business in New York State. Joining us now here in Studio 57 is CBS News campaign reporter and attorney Katrina Kaufman. Katrina, good to have you here. So what are we expecting from the judge's decision today?
As you just said, Trump could be fined hundreds of millions of dollars. They could put a lifetime ban on him in New York's real estate industry, bans on his sons, bans on his company. And this would also be rather uncommon for this law that they're using to prosecute him. It's very rare for victimless crimes to receive these type of punishments. So this could be a very, very big deal for Trump. He could lose his ability to do business in New York, which is really how he began.
Yeah.
And we also know that he is going to appeal this ruling. So today is not the end of things with this case.
Certainly.
Trump is going to appeal. He'll have to put down a substantial amount of money to do so as well.
Hey folks, welcome back to another episode. Jack is here again. So a judge has ordered a sitting president, Donald Trump, to testify under oath in a fraud case, rejecting emergency appeals and warning that no more delays will be tolerated. This has never happened in American history. A president legally compelled to give sworn testimony in a state courtroom while running the country, with staggering implications for the presidency and democracy. Trump's legal team tried every argument: presidential immunity, scheduling conflicts, interference with official duties, to block his testimony. Judge Arthur Engoron knocked them all down, ruling with brutal clarity that being president does not place you above the law. No citizen, not even the occupant of the Oval Office, is beyond the reach of the legal system. Trump's team plans to appeal to New York's highest court.
Based off of the judgment from the judge,
based off of
not for his appeal.
Right. Based off of the judgment, he'll have to put down a significant amount because, Letitia James has asked for $370 million. We don't know what Judge Engoron is actually going to rule. But in order to proceed with an appeal, he'll have to put down a portion of that amount of money at least.
And we've heard, you mentioned victimless crime. We heard that certainly from Trump's defense counsel a lot, that they felt like this is political prosecution. Mm-hmm. And in any other case, that wouldn't be something that would be pursued. But because his name is Donald Trump, that's what's happening. Is that likely to factor into the judge's decision at all, given that he's already determined that he's guilty of fraud?
I don't believe that's actually part of that statute. There doesn't have to be a victim. Also a victim, you could say, is the state. There was a lot of money lost because of what Donald Trump did with his business practices. And that's what Letitia James is asking for. It's called disgorgement, which means ill-gotten gains. So the state is trying to reclaim this money from him.
All right. Let's talk about another case because the former president is not...
But the appellate court that denied their emergency request was blunt. His immunity argument is procedurally baseless. The ruling makes clear that immunity doesn't cover private business dealings from before his presidency, his real estate empire, financial statements, and personal fortune, none of which are shielded by the office he holds. So what happens now? Let me walk you through the scene that is about to unfold, because it is going to be unlike anything we have ever seen. Trump has to show up. He has to walk into that courtroom, past the cameras, past the reporters, past the spectators who have been waiting for this moment. He has to sit in that chair, the witness chair, the one that has been occupied by countless defendants and witnesses over the years.
In a Manhattan courtroom, Donald Trump's financial statements back on trial this morning. But it's Mr. Trump's increasingly inflammatory comments and social media posts outside of court that's landing him in hot water with the judge who will decide the penalty for his namesake company, found liable of engaging in brazen financial fraud.
This trial is a rigged trial. It's a fraudulent trial. Frankly, you saw what was just put out about Schumer and the principal clerk. That is disgraceful.
What was put out by Mr. Trump himself, a photo since taken down of the judge's law clerk posing with Democratic Senate Majority Leader Chuck Schumer, the unmistakable suggestion that Mr. Trump can't get a fair shake at trial as he continues to rail against the case as politically motivated, causing Judge Engoron to hand down a limited gag order. Mr. Trump now banned from talking about court staff. but continuing to attack New York's Attorney General, Letitia James.
Any comment on the gag order?
Her office walking the judge through hours of Mr. Trump's finances in painstaking detail.
He has to raise his right hand and swear to tell the truth, the whole truth, and nothing but the truth, so help him God. And then, prosecutors are going to ask him question after question, hour after hour perhaps, about whether he personally directed the inflation of his asset values to secure better loan terms and lower tax bills. They are going to pull out financial statements he signed, documents with his signature on the bottom line. They are going to show him emails he sent, texts he wrote, notes he scribbled in the margins. They are going to ask him about property valuations, about conversations with bankers, about instructions he gave to his accountants and his lawyers. And he is going to have to answer, right there on the record, under oath, where lying carries real consequences, prison time, fines, the complete destruction of whatever credibility he has left.
Tries to prove the Trump Organization and its executives intentionally falsified their business records in the hopes of securing favorable loan terms and insurance rates, while Mr. Trump's legal team argues the state cannot prove any intent to defraud. Yet on the witness stand, Mr. Trump's longtime accountant at Mazars admitted that the Trump Organization didn't provide his firm with all of the necessary records to accurately complete the financial statement so central to the case.
That is the defendants, and the defendants alone, who provided the numbers, the data, and the false valuations.
Also central to the case, the Republican presidential frontrunner opting to step off the campaign trail, back in court today, saying he too will take the stand.
Mr. Trump, will you be testifying?
Yes, I will. At the appropriate time, I will be.
Now, in reality, Mr. Trump's testimony is still weeks away here. The next major witness to take the stand, likely his company's chief financial officer, who went to prison briefly for tax-related crimes, and Mr. Trump has said was helping to prepare the financial statements that are so contested in this case, guys.
All right. Long road there, Laura. Thank you.
Can you even imagine the pressure in that room? The weight of every word? The knowledge that a single misstatement could become the basis for criminal charges. This case, for those who have not been following every twist and turn through the court system, is the New York civil fraud lawsuit that has been winding its way through the courts for what feels like forever. But do not let the slow pace fool you. The allegations are straightforward, even if the financial details get complicated. Prosecutors say that Trump and his organization systematically inflated the value of their properties and assets when talking to banks to get larger loans, bigger lines of credit, better interest rates. Then they turned around and deflated the value of those same properties when talking to tax authorities to pay less in taxes, to reduce their obligations, to keep more money in their pockets. Same properties, same time periods, wildly different numbers, sometimes differing by hundreds of millions of dollars. And prosecutors say this was not an accident. It was not a mistake by an overworked accountant. It was not a rounding error. It was a deliberate, intentional pattern of deception designed to enrich Trump at the expense of lenders and the public. Trump's defense has always been that real estate valuations are subjective, that different appraisers can come up with different numbers, that beauty is in the eye of the beholder, and so is square footage and building height and property value. He says banks did their own due diligence anyway, so they cannot claim they were fooled. It is a defense that might sound reasonable to someone who has never looked at the documents, never seen the paper trail, never followed the money. But the prosecutors have documents. They have financial statements with Trump's signature on them, his actual signature, the one he uses on official papers. They have internal emails where Trump overrides his own employees. They have testimony from former executives who say they were directed to make the numbers work. And now they are going to have Trump himself under oath. Let me tell you why this testimony is such a big deal. Why it has Trump's legal team losing sleep. Why it has the White House staff on edge. Trump has spent years making statements about his finances in public, on social media, in interviews, at rallies, in books, in television appearances. He has claimed to be worth billions, multiple billions, more billions than anyone has ever seen. He has bragged about his properties, about Trump Tower, about Mar-a-Lago, about his golf courses around the world. He has dismissed questions about his valuations as fake news, as witch hunts, as the desperate tactics of his enemies. But none of those statements were made under oath. None of them carried the risk of perjury charges if they turned out to be false. This testimony is different. This testimony is real. Every word will be transcribed by a court reporter who has taken an oath of accuracy. Every answer will be compared to documents that have been authenticated and entered into evidence. Every claim will be fact-checked by prosecutors who have spent years preparing for this moment, who have reviewed every financial statement, every email, every text message, every internal memo. And if Trump says something that contradicts the documentary evidence, that is a problem. A big problem. If he says something that contradicts what a former employee testified to under oath in a deposition, that is also a problem. If he claims not to remember something that any reasonable person would remember, that is a problem too. His legal team knows this. That is why they fought so hard to prevent this testimony from happening. That is why they threw every procedural obstacle they could find in the path of the court, every motion, every appeal, every request for delay. And that is why the judge's ruling is so devastating for their strategy. The delays are over. The excuses are exhausted. The time for talking is done. Now it is time for answers, real answers, under oath. Think about what this means for the presidency itself, for the institution that has stood for more than 2 centuries. For decades, there has been an understanding that the office carries certain protections, that the president cannot be easily dragged into courtrooms, that the separation of powers requires some deference, some space, some breathing room. You cannot simply drag a sitting president into any courtroom whenever you want. The nation's business matters. The need for the president to focus on governing matters. But this ruling establishes that those protections have limits, that they are not absolute, that they do not cover everything. If the conduct in question happened before the president took office, if it involves private business dealings rather than official acts of state, then the president is accountable just like everyone else, just like any other citizen accused of wrongdoing. That is a precedent that will outlast Trump by decades. It will apply to future presidents from both parties, to Democrats and Republicans alike. It fundamentally changes the calculus of presidential power and accountability. And it is happening right now, in real time, with Trump as the test case, as the guinea pig, as the first sitting president to be put in this position. The timing of all this is impossible to ignore. The political calendar is ticking loudly. Major elections are on the horizon, elections that will determine control of Congress, that will shape the remainder of Trump's term. And now you have a sitting president who is going to be sitting in a New York courtroom answering questions about fraud. The optics are absolutely brutal for him and for his party. His political opponents are already sharpening their knives, rehearsing their lines, planning their media appearances. They are already planning campaign ads, 30-second spots that will run in every swing district. They are already writing speeches about accountability and the rule of law, about how no one is above the law, not even the president. They are going to point to this testimony and say, this is proof that Trump is corrupt, that the system is working, that justice is being served. And his supporters, the ones who have stuck with him through every scandal, every investigation, every impeachment, every indictment, they are going to call this a witch hunt. They are going to say it is political persecution, pure and simple. They are going to say that a Democratic attorney general in a blue state is trying to take down a Republican president by any means necessary, that the legal system has been weaponized against their leader. And honestly, both sides have a point. The case is legitimate, the evidence is real, the allegations are serious, but the politics are also undeniable. The timing is convenient. The actors involved have partisan affiliations. That tension is going to define how this plays out in the court of public opinion, how voters perceive what is happening, whether they see accountability or persecution. Let me walk you through what the prosecutors are actually trying to prove, because the substance of the case matters as much as the spectacle, maybe more. They have assembled what they believe is a mountain of evidence showing that Trump personally directed a years-long scheme to misrepresent the value of his assets. They have financial statements that they say were knowingly false, that Trump signed despite knowing they contained inflated numbers. They have internal communications that they say show Trump overriding his own accountants when those accountants raised concerns about the valuations. Emails where Trump says, "Just make it work. Just get it done. Just put the number I want." They have testimony from witnesses, former employees, former business partners, who say Trump was directly involved in setting the valuations that later turned out to be inflated. And now they want to ask him directly, face to face, in a courtroom. Did you know these numbers were wrong? Did you direct your employees to use these numbers anyway? Did you personally benefit from the loans and tax breaks that resulted from these misrepresentations? How much money did you save? How many loans did you get? Those are the questions, and Trump has to answer them. Trump's legal team has a response, of course. They are not going to roll over. They say that valuations are inherently subjective, that there is no single correct value for any property, that different appraisers can reach different conclusions based on different methodologies. They say that Trump relied on professionals to prepare the financial statements, that he trusted his accountants and his lawyers to get it right. They say that the banks were sophisticated lenders who did their own due diligence and were not harmed, that they had their own appraisers, their own analysts, their own risk management departments. They say that there is no evidence of intent to defraud, no smoking gun, no admission of wrongdoing. And maybe some of those arguments will resonate with a jury, with a judge, with an appellate court. But here is the problem for Trump. He has a long history of making statements that prosecutors can use against him. He has bragged publicly about inflating his net worth, saying that he decides what his properties are worth, that his gut feeling is the only appraisal that matters. He has dismissed the idea that financial statements need to be precise, saying that everyone does it, that it is just business. All of those public statements can be introduced as evidence. All of them can be used to contradict whatever he says under oath. His own words, his own public boasts, his own interviews, his own social media posts could become the rope that hangs him in this case. That is the danger of being a public figure who talks as much as Trump talks. Every word is recorded. Every statement is preserved. And now those words are coming back to haunt him. And let us not forget that this is not the only legal battle Trump is facing. Far from it. This is just one front in a multi-front war. There is the ongoing criminal case related to hush money payments made during the campaign, payments that prosecutors say violated campaign finance laws. There is the defamation case from E. Jean Carroll, a writer who accused Trump of sexual assault and then was sued by Trump for defamation when she spoke out. There is the classified documents investigation, which continues to move forward despite delays and legal challenges. There are state cases in multiple jurisdictions, including Georgia, where Trump faces criminal charges related to election interference. There are federal investigations that continue to loom, that could produce new charges at any time. It is a legal avalanche, a tidal wave of litigation, and this testimony order just added another massive boulder to the pile, another weight on an already groaning legal defense structure. The cumulative effect is staggering. Trump is being forced to fight on multiple fronts simultaneously, each battle demanding his time, his attention, his money, his energy, his focus. Something has to give eventually. No one can sustain that level of legal pressure forever, not even a billionaire, not even a former reality television star, not even a sitting president. The judge who issued this ruling, Arthur Engoron, has already demonstrated that he is not intimidated by Trump or by Trump's legal tactics. This is the same judge who fined Trump for violating gag orders, for speaking about court staff in ways the judge deemed inappropriate. The same judge who sanctioned Trump's lawyers for filing frivolous motions, motions that had no legal basis and seemed designed only to delay. The same judge who has consistently ruled that the case will move forward no matter how many delays Trump tries to throw at it, no matter how many appeals, no matter how many emergency requests. So when Judge Engoron says testimony will proceed as scheduled, he means it. There is no more wiggle room. There are no more procedural tricks left to try. The well is dry. Trump has to show up. Now, what happens if Trump simply refuses to comply? Can he do that? Let me be clear about the law. Technically, no, he cannot. If he defies a court order, he could be held in contempt of court. That is a legal finding that can carry serious consequences. The judge could issue sanctions, financial penalties that increase every day Trump refuses to comply. The judge could even issue a bench warrant for his arrest, though the practicalities of enforcing a warrant against a sitting president protected by the Secret Service are complicated, to say the least. You cannot exactly have U.S. Marshals walking into the White House to arrest the commander-in-chief. But Trump is not going to refuse to show up. His lawyers will not let him. Defying a court order would be an absolute legal and political disaster of the highest order. It would hand his opponents a massive weapon, a ready-made attack ad. It would undermine his entire defense strategy, making him look guilty before he even answers a single question. It would make him look afraid to answer questions, afraid of the truth. So he will show up. He will sit in that chair. He will raise his right hand, and then we will see what happens. The question that everyone is asking, the question that legal analysts are debating, the question that political strategists are gaming out, is how Trump will handle the testimony. His past depositions offer some clues, and they are not encouraging for his legal team. In previous sworn testimony, in previous depositions, Trump has been combative, argumentative, unwilling to accept the premise of questions. He has been evasive, giving answers that do not actually answer the question. He has claimed not to remember things that seemed pretty memorable, like meetings with key witnesses, conversations about important documents. He has contradicted himself, saying one thing in one deposition and the opposite in another. He has given answers that his own lawyers later had to clean up in court filings, to explain away, to try to walk back. And prosecutors have used those deposition transcripts against him in other cases as evidence of his credibility issues. So there is a track record here, a history, a pattern, and it is not a great one for someone about to testify again. The best case scenario for Trump is that his lawyers prep him extensively, drill him on every possible question, and he manages to stay disciplined and give carefully worded answers that do not create new problems. The most likely scenario, based on history and based on Trump's personality, is that he starts off disciplined and then gets frustrated with the questioning, annoyed by the prosecutors, and goes off script, saying things his lawyers wish he had not said, making statements that will be quoted in headlines the next morning. The worst case scenario is that he completely loses his cool, attacks the prosecutors personally, makes wild claims about conspiracies and deep state plots, and creates a disaster for his legal team that no amount of cleanup can fix. Trump does not like being challenged. He does not like being questioned. He does not like being told what to do. And when he feels cornered, he tends to lash out, to punch back, to escalate. That works in a rally. That works on social media. Under oath in a courtroom, it is a recipe for disaster, for perjury referrals, for contempt findings, for everything his lawyers have been trying to avoid. Let us talk about what is at stake here, beyond the immediate legal consequences, because the stakes go far beyond this one case. This case could result in massive financial penalties. We are talking potentially hundreds of millions of dollars in fines, enough to put a serious dent in even Trump's claimed fortune. It could result in Trump being barred from doing business in New York, which would be a devastating blow to his business empire, to Trump Tower, to his properties, to his brand. It could result in damage to his personal fortune and his reputation that no amount of fundraising can repair. And if the evidence of fraud is strong enough, if the judge or jury finds that Trump acted with intent to deceive, it could lead to criminal referrals. That would be a separate process with a higher burden of proof, beyond a reasonable doubt, instead of a preponderance of the evidence. But it is not off the table. It is not impossible. So the stakes are real. This is not just about political embarrassment or media coverage. This is about Trump's money, his business, his legacy, and potentially his freedom if criminal charges follow from the civil findings. But the implications go even further than that, into the realm of constitutional law and presidential power. This is a defining moment for the American legal system, a test of whether the rule of law can hold against a sitting president. For years, there has been a debate among legal scholars about whether a sitting president can be subjected to state court proceedings, about whether federal immunity trumps state authority. The Supreme Court has addressed some of these questions, but not all of them, leaving room for interpretation, for argument, for litigation. This case is testing the boundaries of presidential power in real time, with real consequences. And the courts are drawing a line. They are saying that presidential immunity has limits, that it does not extend to private conduct, that the president is not a king, that accountability still matters in America, that no one, not even the president, is above the law. Whether you agree with that principle or think it is being applied unfairly to Trump, the fact that it is being applied at all is historically significant. It sets a precedent that will shape the relationship between the presidency and the legal system for generations to come, for your children and your grandchildren. And let us not ignore the political dimension, because politics is never far from the surface in any story involving Trump. The midterm elections are approaching, and this testimony is going to be front and center in every political conversation, every debate, every advertisement. Democrats are going to hammer on it. They are going to say that Trump is too distracted by legal troubles to govern effectively, that his mind is on his lawyers instead of on the nation's problems. They are going to say that his scandals are a liability for the entire Republican Party, that any candidate who supports him is supporting corruption. They are going to use his testimony in campaign ads and fundraising emails, in debate questions and press conferences. Republicans, on the other hand, are going to rally around him even harder. They are going to say that this is political persecution by a hostile legal system, that the deep state is trying to take down a duly elected president. They are going to say that Trump is fighting for them against the establishment, that he is the only one willing to stand up to the machine. Both sides have their scripts written. Both sides know exactly how they are going to frame this. The question is, which narrative breaks through to the voters who actually decide elections? The independents in the middle who are tired of the chaos and just want stability, who are exhausted by the constant drama and want someone who can get things done. There is also the practical question of governing, the day-to-day reality of running the most powerful nation on earth. How can a president effectively run the country while spending significant time dealing with legal battles? How can he focus on policy, on foreign affairs, on national security, on the economy, when his attention is divided, when his mind is elsewhere? Trump has always prided himself on being a multitasker, on juggling multiple priorities at once, on being able to handle anything that comes his way. But there is a difference between juggling business deals and juggling criminal and civil litigation while also serving as commander-in-chief. The strain is real. The distraction is real. The toll on his decision-making, on his temperament, on his ability to lead is real. And it is only going to get worse as more cases move forward, as more testimony is demanded, as more legal deadlines approach. Something has to give.